Hi everyone, my name is Maya and welcome back to another update in the Donna Adelson case. This new development involves the petition of writ for prohibition that Donna filed with the appellate court. Her appellate lawyer, who's in Tampa, just filed a motion for rehearing and a motion for rehearing en banc, asking for the full court to consider the issues.
Another Ed Talk, better than a TED Talk, and another update in the Donna Adelson case. This time, the update concerns her efforts to have the appellate court, the First District Court of Appeal, rule that Judge Everett should have granted Donna Adelson's amended motion to disqualify him from the case. Hi, I'm Ed, not AI, and as you may recall, we've been providing you coverage about this issue here on the channel. And now, we are ready to announce the result of the petition. It was a huge win for the Florida Attorney General's office and the prosecution. Judge Robert Long wrote the opinion of the court denying the petition for writ of prohibition and also denying the requests to treat the filings in the appellate court confidential. The opinion is great and self-explanatory, so I'm going to go ahead and read it to you. Title, First District Court of Appeals, State of Florida, number 1D 2025-0949. Donna S. Adelson, Petitioner v. State of Florida, Respondent. Petition for writ of prohibition. Original jurisdiction, Stephen S. Everett, Judge. Dated May 9th, 2025. Signed, Judge Long. Donna Adelson seeks a writ of prohibition to prevent the trial judge from presiding over her criminal trial. Adelson argues the trial judge should have recused himself based on her amended motion to disqualify. She claims that the trial judge engaged in improper ex parte communications with the state by reviewing search and seizure warrant applications. The warrant applications involved Adelson's husband's phone records and a wiretap of his cell phone. Adelson claims that because the warrants relate in part to her and her criminal prosecution, the judge's review of these warrant applications constituted ex parte communications and has given her a reasonable fear that she will not receive a fair and impartial trial. These claims are meritless and facially insufficient. We deny the petition and right to explain why. It is routine for trial judges to review warrant applications and then preside over the resulting criminal trials. Trial judges also commonly issue arrest and search warrants for criminal defendants that have pending cases before them. Adelson's petition amounts to an attack on this common practice. We begin with the general prohibition on ex parte communications. See Florida Code of Judicial Conduct, Canon 3, paren B, paren 7. Quoting, the Code of Judicial Conduct prevents judges from initiating or considering ex parte communications concerning a pending proceeding, unquote. See Reichman v. State. But there are times when a judge must engage in ex parte communications. The Code of Conduct contemplates this and permits a judge to, quote, initiate or consider any ex parte communications when expressly authorized by law to do so, unquote. Florida Code of Judicial Conduct, Canon 3, paren B, paren 7, paren E. The review of arrest and search warrant applications is a core function of the courts. Article 1, Section 12 of the Florida Constitution addresses searches and seizures. It requires a judicial determination of probable cause before a warrant can be issued. Article 1, Subsection 12, Florida Constitution. It also provides, quote, this right shall be construed in conformity with the Fourth Amendment of the United States Constitution as interpreted by the United States Supreme Court. And the Supreme Court has explained, quoting, the pre-search proceeding is necessary ex parte, since the subject of the search cannot be tipped off to the application for a warrant lest he destroy or remove evidence, unquote. Franks v. Delaware. That is to say, ex parte judicial review of warrant applications is constitutionally authorized. Judicial review of warrant applications is also authorized by Florida statute. Quoting, a search warrant authorized by law may be issued by any judge, including the committing judge of the trial court having jurisdiction where the place, vehicle, or thing to be searched may be, unquote. And with respect to wiretapping in particular, quoting, upon such application, the judge may enter an ex parte order as requested or as modified, authorizing or approving interception of wire, oral, or electronic communications, unquote. In short, the ex parte communications in this case were expressly authorized by law. They are, therefore, not subject to the general prohibition on ex parte communications. Because Adelson does not allege any ex parte communication beyond the ordinary authorized review of warrant applications, the petition is facially insufficient. Adelson also moves this court to determine the confidentiality of records filed in this court, including the petition and appendix. Adelson, however, fails to demonstrate that anything in the records satisfies a condition that would establish confidentiality under Florida Rule of General Practice and Judicial Administration 2.420(c)(9). Thus, her motions to determine confidentiality are also denied. Rowe and Wilbury, JJ concur.
Now, I'll pass it on to Ed, who's not AI, to read the full developments.
Donna's appellate lawyer, Rachael Reese, out of Tampa, filed a motion for rehearing and motion for rehearing en banc in the First District Court of Appeal with respect to the court's decision denying her petition for writ of prohibition, which sought a declaration from the appellate court that Judge Everett should have granted Donna Adelson's amended motion to disqualify him from the case. The gist of the motion is that although a judge generally has the authority to consider ex parte communications from law enforcement regarding applications for warrants, what happened in this matter goes beyond that in two ways. The first is that Judge Everett, when law enforcement sought him out to sign the warrants, was already presiding over the Donna Adelson case, and that the allegations, which were proven false according to Donna's lawyers, suggested misconduct by Donna Adelson and her lawyers. Donna's lawyer surmises that, as a result, Donna has a reasonable fear that Judge Everett was not fully impartial when considering that various motions that were being heard in the meantime by Judge Everett, that is, motions heard while Judge Everett had the information contained in the applications for the warrants in his mind before the defense was aware of the allegations and could dispute them. And as a result, Judge Everett should have disqualified himself. Second, Donna's lawyer argues that there was actual evidence that Judge Everett misused the information he received in the warrants applications when ruling on Donna's motion for bond, when Judge Everett noted that while in jail, Donna still had plenty of opportunities to meet with her former lawyers and her current lawyers to prepare for trial. Donna's lawyers claim that this announcement was not based on evidence elicited during the hearing, but was derived from the warrant applications which concerned in large part the attorney-client meetings between Donna and her current lawyers and communications with Harvey during those meetings. We will now read to you the most pertinent portions of the motion, and then we will share a brief commentary. You should note that the state of Florida will have an opportunity to respond to the motion, and we have not yet seen this response. We expect a ruling to be issued not earlier than 20 days from now. Motion for rehearing. Paragraph 12. The summary provided by the court is as follows. Adelson argues the trial judge should have recused himself based on her amended motion to disqualify. She claims that the trial judge engaged in improper ex parte communications with the state by reviewing search and seizure warrant applications. The warrant applications involved Adelson's husband's phone records and a wiretap of his cell phone. Adelson claims that, because the warrants relate in part to her and her criminal prosecution, the judge's review of these warrant applications constituted ex parte communications and has given her a reasonable fear that she will not receive a fair and impartial trial. These claims are meritless and facially insufficient. We deny the petition and write to explain why. It is routine for trial judges to review warrant applications and then preside over the resulting criminal trials. Trial judges also commonly issue arrest and search warrants for criminal defendants that have pending cases before them. Adelson's petition amounts to an attack on this common practice. 13. The decision provides a thorough analysis about 1. The general prohibition on ex parte communications, 2. The authorization provided by law concerning the judicial review of warrant applications, and 3. How those two legal concepts expressly authorized the communication that took place in Mrs. Adelson's case. 14. Undersigned counsel is aware of and agrees with the legal analysis contained within the decision as it relates to the basic principles associated with the lawful practice of law enforcement or its agents having ex parte communication with a judge for purposes of obtaining search and or arrest warrants prior to arrest, as well as the possibility that a judge approving the warrant may thereafter be assigned or involved with that case. 15. However, the instant motion is being filed because the decision falls short by failing to recognize that the ex parte communication in this case do not fall within the recognized legal authority noted. A simple ex parte communication between law enforcement and a judge for a warrant is not what transpired in Mrs. Adelson's case. 16. Here, at the time of the ex parte communications, the case against Mrs. Adelson had been pending for over a year, was set for trial, and hearings on pending motions were yet to be heard. 17. Without any notice to the defense, new, very serious allegations based on false information were relayed to Judge Everett and then were clearly considered at the time of ruling on the pending motions. Specifically, Judge Everett considered the false information learned at the hearing on the motion to set bond. 18. Had counsel for Mrs. Adelson been aware of the knowledge that the trial court had gained in those ex parte communications, the defense would have been able to argue against those false allegations from the confidential informant, provide the trial court with proof of the confidential informant's, CI's, lengthy criminal record, which included numerous felony convictions and crimes involving dishonesty, and ensure that no further harm came from the allegations. 19. The issue here is not whether the office of the state attorney or members of law enforcement are permitted to have ex parte communications with the judge, but rather the timing in which those communications were had. More importantly, it is about the impact that those communications had on the trial court when ruling on issues directly related to the very matters in which the court had learned ex parte. 20. Proof of such is contained within the face of the record, including the mention in the order denying Mrs. Adelson's bond that the trial court was aware that Mrs. Adelson was spending plenty of time with current counsel to prepare for trial. This information was relayed to Judge Everett during the ex parte communications with the very investigator in which Mrs. Adelson's case, who will ultimately testify against her at trial, which will be presided over by Judge Everett. 21. There is absolutely nothing in the record about the amount of time that Mrs. Adelson has been speaking to counsel on the phone about her case, or the amount of time or number of visits that Mrs. Adelson had with counsel at the Leon County Jail. 22. Even without the record evidence of the interaction and the resulting impact of such, the fact that one party was able to have unfettered access to the presiding judge on a pending case and provided them with information that was clearly intended to create a bias against the other party without providing the other party with an opportunity to be heard is inherently unfair. 23. The error with the current decision is that it does not contain a single hint of considering this critical, distinguishing facts and whether those facts would have provided a facially sufficient reason to seek disqualification in this case. 24. Ironically, the very law cited by this court in the current decision requires disqualification of Judge Everett because if the communication was authorized as found, then there would have been no reason not to notify the defense and provide them with an opportunity to be heard. See Code of Judicial Conduct, Canon 3, paren B, paren 7. Yet neither the trial court nor the communicating party, i.e. the state, ever notified the defense of the ex parte communications in violation of the law. 25. On that basis alone, Mrs. Adelson cannot receive a fair trial under the authority of Judge Everett. 26. In addition to the overall reliance on the facts learned through the ex parte communication, the other overlooked fact is how damaging the false allegations were that were learned during the communication. 27. The law at issue clearly states that when a motion to disqualify is filed, the question of whether the allegations are facially sufficient requires the court to accept the facts alleged as true and to consider them from the viewpoint of the movement. See McKenzie v. Superkids Bargain Store, Inc. 28. With that legal principle in mind, the most critical facts that supported the request for disqualification were as follows. On December 19, 2024, the chief investigator for the SAO, the State Attorney's Office, presented an application for warrant requesting communication records and an affidavit resulting in Judge Everett authorizing the December 19, 2024 warrant requesting communication records for Harvey Adelson's cellular phone. The affidavit presented to Judge Everett in support of the application includes the following allegation, with no factual basis. At this time, Harvey Adelson is the most frequent caller for Donna Adelson, but it is apparent Donna relays information to Harvey through attorney privilege calls. These calls are not monitored. Cellular phones have played a critical role in this investigation. As the investigation proceeds, the location of cellular devices as well as communication patterns become relevant. The cellular phone number for Harvey Adelson during this entire investigation and the one he still communicates with Donna on, this order is being requested to determine any patterns with privilege calls that cannot be monitored as well as any potential threats that may be orchestrated. On January 9, 2025, the chief investigator for the SAO again appeared before Judge Everett ex parte, this time presenting an application for a warrant authorizing the installation and use of both a pen register with enhanced caller identification and trap and trace device, as well as an affidavit. Based on the application and affidavit, on January 10, 2025, Judge Everett signed the warrant authorizing the installation and use of both a pen register with enhanced caller identification and trap and trace device for Harvey Adelson's cellular phone. In the affidavit, the state alleged that a jailhouse informant alleged Mrs. Adelson was offering to pay for witness testimony. The affidavit continues as follows. The phone records for Harvey Adelson were reviewed along with jail phone call records and dates and times for attorney visits. There are overlapping communication records between Harvey Adelson, the defense attorney's cell phone, and attorney visits. It was also learned that Harvey Adelson has changed carriers from AT&T to Verizon since the issuance of the previous order. As with the December 19, 2024 affidavit, the undersigned counsel has already determined factual assertions made in the January 9, 2025 affidavit to be false. According to the memorandum of this investigation authored by the SAO chief investigator, the wiretap was terminated on February 24, 2025. Significantly, the memorandum documents that neither Harvey Adelson nor the undersigned counsel engaged in any behavior with a potential witness which justified the overreach by the state approved by the court. 29. The amended motion to disqualify also included that the, quote, application and probable cause affidavit submitted in furtherance of the Title III wiretap contain allegations which the undersigned counsel have determined to be false. 30. In addition to the verbiage identified within the amended motion to disqualify filed below, the false allegations within the warrant applications are also key to the court's analysis because it was Judge Everett's consideration of that language that led to this petition. 31. Specifically, the warrant application presented a factual scenario that falsely suggested Mrs. Adelson and her attorneys were using privileged visitation and privileged communication to coordinate illegal acts involving witnesses that could be called at Mrs. Adelson's trial. Moreover, because the application clearly sought to pierce the confidential veil of attorney-client privilege, it went one step further and presented false information to help corroborate the falsities. Specifically, the application alleged that the jail phone call records, as well as the dates and times for attorney visits, overlapped and suggested that two attorneys in good standing with the Florida bar were planning to present false information on Mrs. Adelson's behalf or potentially tamper with witnesses, all of which have proven to be false. Footnote. Not only have certain allegations involving both Mrs. Adelson and the defense been proven false, but the actual supporting records that were offered to support those claims were also proven false, such as visitation records and phone logs. Furthermore, the mere suggestion proposed by the application concerning Mrs. Adelson and her communications with counsel are not only reckless, but deeply offensive and undermines the integrity of the proceedings entirely. 32. Therefore, although the legal principle cited in the current decision is legally correct, it does not accurately address what transpired in this case. Moreover, it does not consider the damaging false information provided or the impact that said information has had or could have in the future on Mrs. Adelson's case. 33. The current decision's failure to consider these critical portions of this issue must be remedied through a rehearing. C. Motion for rehearing en banc. 34. Arguing in the alternative, the undersigned asks this court to grant a rehearing en banc and allow all members of the court to consider the issue presented because it is one of exceptional importance. 35. As discussed within the current decision, ex parte communications are prohibited except for a few narrow exceptions, one of those exceptions being the presentation of a sworn application for warrants. This practice is one that will continue in future cases as it is a necessary feature of our legal system. 36. However, allowing the current decision to stand presents a loophole that invites abuse without firm boundaries and accountability. The danger is that actors who seek to manipulate the judicial process in the future will exploit exceptions to the prohibition on ex parte communications as a backdoor to improperly influence the court. The current decision suggests that said improper influence, if sought legally and with authorization, is okay and will not provide a legitimate basis to seek disqualification. 37. The panel's decision, if allowed to stand, continues to uphold the harmful precedent that allows this unconstitutional and shocking behavior. 38. As a result, the undersigned asks that this case be reheard en banc. Certificate of Counsel per Rule 9.331, I express a belief, based upon a reasoned and studied professional judgment, that the case or issue is of exceptional importance. Signed, Rachael E. Reese, Joshua D. Zellman, Jackie Fulford. Conclusion. Wherefore, the petitioner by and through undersigned counsel asks that this court grant the instant motion for rehearing or, alternatively, grant the motion for rehearing en banc and allow a majority of the judges within this court consider the matter as it involves an issue of exceptional importance. Respectfully submitted, Rachael E. Reese, Joshua D. Zellman, Jackie Fulford. Generally speaking, if ex parte communications are allowed, it should not matter in what portion of the proceeding they happen. The judge considering the warrant application knows that these are based on a one-sided view of the evidence and that when tested by the justice system, the allegations in the affidavit may be proven to be false or partially false. There are small counties with only one judge available to consider applications for warrants. We see no reason for a Donna Adelson exception to the general rule. We also note that there is no citation to any cases in support of the motion and that the citation to the canons of judicial conduct omit reference to the exceptions noted in the canon. Specifically, Donna's lawyer cites the Code of Judicial Conduct, Canon 3, paren B, paren 7, for the proposition that, quote, ironically, the very law cited by this court in the current decision requires disqualification of Judge Everett because if the ex parte communication to Judge Everett was authorized as found, then there would have been no reason not to notify the defense and provide them with an opportunity to be heard, unquote. Motion for rehearing, paragraph 24. In other words, Donna's lawyer suggests that even if Judge Everett was allowed to communicate ex parte with investigators about an application for warrant, he should then notify the defense about those communications, in essence, tipping the defense about what the investigators were investigating. All right, so let's look at the pertinent portions of the Code of Judicial Conduct. Canon 3, paren B, paren 7 provides as follows. A judge shall perform the duties of judicial office impartially and diligently. B, adjudicative responsibilities. 7, a judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. A judge shall not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of the parties concerning a pending or impending proceeding except that, A, where circumstances require ex parte communications for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits are authorized, provided, 1, the judge reasonably believes that no party will gain a procedural or tactical advantage as a result of the ex parte communication, and 2, the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and allows an opportunity to respond. And E, a judge may initiate or consider any ex parte communications when expressly authorized by law to do so. Donna's lawyer seems to be confused. The court, in its opinion, cited subparagraph 3, which provides that a judge may consider ex parte communications when expressly authorized to do so by law. That subsection says nothing about notifying the other side of the communication. Donna's lawyer seems to be suggesting that the requirements in subsection A apply here, but they clearly do not. Subsection A, which does require the judge to make provision to notify all parties of the substance of the ex parte communication, provides limited authorization for some ex parte communications, quoting, ex parte communications for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits are authorized, unquote. Clearly, not the type of communication at issue here, an application for a warrant that, by nature, needs to be kept secret. We also note that one should consider all of the unsupported references to the supposed falsehood of the information in the warrant applications with a grain of salt. Indeed, it seems that much of the motion practice related to this issue is not so much about getting rid of Judge Everett and is more about protecting the name and reputation of the defense attorneys. This, of course, raises an interesting question. Did the fact that the prosecutors investigated the conduct of the defense attorneys create a conflict of interest where they are no longer, quote, conflict-free, unquote? We think it would be prudent for Judge Everett to run a new conflict of interest colloquy and for the defense attorneys to obtain a waiver of any and all possible conflicts of interest in light of this. There is also the issue that they are claiming attorney-client privilege with respect to their communications with an alleged, but not yet charged, co-conspirator, Harvey Adelson. The conflict issues seem to be getting quite messy in this case. While we have not yet seen the state's response, obtaining rehearing or rehearing en banc is extremely hard, and the motion does not seem to justify any reconsideration. From reading the opinion written by Judge Long, the appellate panel that considered the issue was fully aware of Donna's arguments and rejected them. To us, the efforts to remove Judge Everett make little sense. He's an excellent jurist who's always been very fair to the defendants. Furthermore, any judge, not just Judge Everett, knows that a warrant application may be disproved down the line. We do not think that Judge Everett's reference to trial preparation should necessarily be tied to any knowledge he gained through the warrant applications. The extensive preparation is self-evident from various discussions between the lawyers and the judge at various hearings, where mention was made by the defense lawyers of meetings with Donna Adelson at the jail. Overall, we doubt that the rehearing will be granted in a way that would change the ruling. We should find out one way or the other within the next 20 days or so. Until then, this is Ed, not AI, Deep Dive True Crime.
Thank you guys for making it to the end of